We're live. We're good. Good to go. Right, good afternoon everybody. Phil Brunner here again, Bailiwick Legal. Live to talk about grains contracts. Alright, usual stuff, the disclaimer. The information contained in this presentation, both visual and oral, is provided for informational purposes only and should not be construed as legal advice on the matters discussed today. Who's Bailiwick? Well, most of you should know who we are by now, but if you don't, we're a specialist firm across the industries of agribusiness and tourism. Whilst we concentrate on those two predominant areas, we do work in other industries. Most people understand that the law does overlap all industries. We specialise in commercial, contractual and transactional law. So, grain contracts. Now, I understand most of you will have started seeding, some of you even as early as March, and a lot of you will probably be involved in that activity right now. And by and large, I think we've had a pretty reasonable start to the season across the state, so that's a good thing. Why should you be thinking about grain contracts now? Well, I would hazard a guess that there's a small percentage of you that have actually already forward contracted sales of grain for this season. Some of you won't look to do that exercise until maybe mid-year, once you've had a look at how good the crop's growing and the outlook, and some of you will wait till the end of the year. And some of you will wait till next year, once everything's in the bin and you've got something to actually sell. Right, so I think that sets the scene. Grain contracts. What can we say about grain contracts? Overall, generally, by and large, the incidence of written contracts has increased over my involvement with the agricultural sector. So if we look at sort of 20 plus years, the incidence that grain contracts are now being converted to written form is probably, I would hazard a guess, well above 50%, but there are still agreements done where there's no written contract traded between the parties. You should rectify that. Grain contracts are not governed, if you like, by any statutory overarching rules. They're not like contracts that have a code of conduct attached to them, such as what's now the case in the dairy industry, and the horticultural code of conduct applies in horticultural industry as well, as dealing with agents and exporters. So the basic law, legal principles still apply to those types of contracts, but there's no statutory regulation, if you like, of those contracts. That means the parties are at liberty to negotiate and bargain at arm's length, and the law generally will presume that both parties have an equal bargaining position, so not one party is dominant over the other. Now, in my experience, that's not necessarily always the case, but by and large, from a policy perspective, that's what the law is saying. So, when we look at grain contracts, what are some of the things that really are important to ensure that you've covered off on? By and large, this is a transaction where the outcome is critical for a grain grower. If you don't get that transaction right and things go a bit pear-shaped, you're talking about your annual income or a significant portion of it. And so it's an area where I think growers perhaps don't tend to have a great deal of interest generally what are the terms of my grain sale contract. But in my humble view, they should, because it's quite a significant issue. It's really akin to maybe, when you go out there and buy that $600,000 header. Often you don't really take note of the fine print in those contracts either, but you're spending $600,000. So the reverse here is you have an expectation that your crop might return, something in the quantity of, seven-figure sum. You should be giving a fair bit of attention to the terms and conditions of the contract or contracts for sale that you're entering into in relation to the sale of that commodity. So some of the things that I've sort of highlighted for the purpose of discussion today, which I think are quite important in the context of grain contracts generally, I'll cover off on, and we'll get to that. The first one, though, is not generally a feature of contracts, but it does appear as a term, if you like, under the Dairy Industry Code of Conduct. And that's where the purchaser under the dairy system, the purchaser of milk, when they put a contract to a party, there's a cooling off period. All right, so the prospective processor, I should say producer, the prospective producer has an ability to consider the offer, consider the contract, and if they don't like it, they can walk away within that 14-day cooling off period. When it gets to those contracts of grain sales that are typically done over the phone, and then you get an email contract 24 hours later, in my view, I think they're typically situations where matters tend to go wrong, in the sense that sometimes the grower believes they haven't actually entered into a contract. The grain buyer says, well, you have, we agreed over the phone, I've sent you a contract. I think in those types of circumstances, a cooling off period is probably warranted. And so that's a policy decision, I think, for the players within the marketplace to actually think about and maybe develop. All right, some of the key components of a contract. Price, obviously. Price. What are you actually getting for that grain? Is price dependent upon any standard or quality? Is price dependent on the type of grain? And is price dependent on what the grain will ultimately be used for, right? And so if we look at barley can be used for malt, and it can be used for feed. So what are you actually selling, and what's the price the market's going to pay? And does your contract actually identify those things? Second big thing is the specifications. Are there particular quality measures that are required in relation to the grain? Now, this is an issue that's really probably coming more to the fore with what's the term I'm looking for here? Certification and organic farming is, well, if certification is a requirement, whoever might be certifying is a requirement by the grain buyer, that needs to be pretty clear and expressed within the document. And if coming to another part of this discussion, if there's a problem on delivery, in the sense that the grain doesn't meet that specification, what then happens? So what does the contract do in relation to that situation where the grain you deliver may not actually meet the specification requirements of the contract? And is the grain buyer actually obligated to take that grain? And have you breached the contract? So some of those issues really need to be dealt with. in the contract issue. And some contracts I've seen, and no doubt many growers would be familiar with, is where the grain hasn't perhaps met the specification. It might not be malt grain, it might be feed grain, so there's an adjustment of price. And those mechanisms really should be dealt with in the written form of the contract at the time of entering into the contract. It gets harder to deal with those types of problems if the contract is silent, and then the issue gets blown up on delivery itself. And that's a pressure point for grower, it's a pressure point for the grain buyer as well, because the activity of delivery really does absorb a lot of time for both parties, and rarely do they devote then sufficient attention to the dispute, and often that's part of why things do become a dispute. And so when we look at contracts in the marketplace at the moment, we know that many, in fact most, if not all, grain buyers have what they would say are template contracts. I would refer to them as standard form contracts, and in some respects, and this will depend on your circumstances, your individual circumstances, those contracts might fall under the unfair contract provisions under the corporations law. Sorry, the consumer and competition laws. So if you do fall within the small business definition as defined in that regime, there may be avenues of redress for you in the context of a template contract that's being provided to you. And it's always wise to actually have a look at this, as I said, at the time you're entering into a contract, but it's not necessarily too late once a dispute has arisen. But it would be handy and helpful if these things were dealt with up front. So some of those unfair terms might be one party has a unilateral right to terminate the contract for no reason at all. There might be penalty provisions where there's a breach of the contract and there's a penalty imposed. There might be a penalty in the context of a degrading of the price payable. One party might have the ability, and this would usually be the grain buyer, to vary the terms of that contract without further discussion or negotiation. And there are terms often in most commercial contracts, at least, and particularly grain contracts, there are always terms where the grain buyer seeks to limit its liability in relation to representations made, conduct and the like. And those terms need to be reviewed particularly carefully to see whether they would fall within an unfair contract term. So perhaps two primary issues in grain contracts that often cause a lot of unrest and dispute is when title to the grain actually passes and when risk in the grain passes. So the easy example there is, well, risk will probably pass as soon as you drop it into the bin. All right, you've taken it by truck to the local CBH bin, you've dropped it in the bin, and you no longer have any control over where that grain goes from that point in time. Ordinarily, in a very generic sense, the risk in that grain has then passed. Who is it passed to? Well, that's going to depend on what your contract says. Title to the grain itself may not have passed at that point. You might still have ownership of the grain even though it's in CBH's bin, but you don't have any risk attached to it. Those things are possible. Title doesn't necessarily need to flow at the same time as risk. So those parameters, those aberrations, if you like, they're quite possible to occur. Passing of title is quite an interesting issue in itself, because a lot of the contracts I've seen, and I'm being quite general here, that are put out by some of the sort of major bigger grain buyers in the marketplace, do build in a PPSR, personal property security registration. They do build in a PPSR protection for the grower in the context of title not passing until final payment for that grain has been made. I say that's a benefit to the grower because under the personal property security legislation, the grower then has a right to effectively follow the chain of ownership of that grain to try and recover any unpaid monies in the context of the purchase price should the buyer default. But because of the advent of the personal property securities regime, and the passing of title being a critical point in this, and hopefully growers thinking that they need security over their grain whilst they actually get paid, or before they get paid, that's quite an important issue within a contract itself. I hope I've explained that reasonably well. Okay, a couple of the other things that give rise to something people should be looking at are transport. Often in a grain contract, it will simply just say transport to the point of deposit of the grain shall be done by the grower. And so that's okay, right? That's not typically a problem. You understand that you bear the cost of trucking your grain to the bin. In other commodities, that position is not necessarily as clear, particularly where the product is actually picked up by the buyer. And so if you have a situation where a buyer is actually coming to your premise to pick up grain or any other commodity, the issue of transport costs and indeed passing of risk and title, those things do often work in combination with each other in a contractual sense. Those things become quite important. All right, insurances. Who's taking out insurance on your crop? Do you have insurance for the crop when it's being transported? Do you have insurance for the crop where you may have already passed risk? Risk may have passed in it, but you still have ownership of it. Do you have some sort of insurance cover there? To be honest, I don't know the answer to that. I don't even know whether there's an insurance product out there that would cater for that. But certainly having some additional security in relation to your crop and the value of that crop during that transition process from farm to final buyer is probably worth looking at. Now, I'm not saying necessarily that the grower should be taking out that insurance. Where risk has passed, you really want insurance to be taken out by the buyer. So the buyer has safeguarded your interest in that grain such that if something then happens to it, you still will be paid. So insurance becomes another important issue. Something that has also been a feature perhaps for the last 10 years or more, a bit more of a regular feature, is what happens where you have a washout. You simply can't produce because of seasonal conditions. You haven't been able to produce a crop at all, or what you've produced is simply insufficient, significantly insufficient to meet the contracted amount. Are there washout provisions? Can you transfer that contract into the following year? Is there a penalty for that, or is there a mechanism to even make that available? And if so, what's the price that you might get paid next year for it? So to me, that type of provision in a contract is a necessity in this industry. you take a huge risk every year in putting a crop in. Will it rain? Will I have enough resources to actually get this crop out of the ground and grow and harvest it? And there's so many events, as you know, across the course of the year that can impact on the outcome of that crop. So I think washout provisions in contracts are really a must, and I think a must. And if you don't have a washout provision in a contract, maybe you're selling to the wrong buyer. Termination provisions. What events give rise to a termination of the contract? And maybe an event of termination might be simply that you haven't been able to produce against the tonnage required at all due to seasonal events. Right? Maybe that's a point of termination. I've not seen that in a contract to date, but maybe it should be. So sometimes these contracts do contain termination events. That to me is a little strange, given the nature of these contracts themselves, but they're still there generally, and it's a question really of ascertaining the rights of the grower if the grain buyer does in fact terminate. Right, now we get to what I'm going to say is the last point in this discussion, and that is dispute resolution. You've delivered grain, you're not being paid, there's a dispute. There's some question about the quality or standard of the grain, or the grain buyers degraded the grain for some reason which you're not happy about. You've got a dispute. What does your contract say about resolving that dispute, if anything? And I say if anything, perhaps a little flippantly, because most of the contracts I read in this area do have mechanisms for resolution of dispute, and a lot of them include reference to the Grain Trade Australia Rules of Trade as being part of the contract, and also for the resolution of disputes they refer the disputes to the Grain Trade dispute resolution procedures. Now, on a personal level, I don't like that as a mechanism, because it locks the grower out of taking a dispute to court. Right? That's it. You're forced into an arbitration in those circumstances. Now, ordinarily, a lot of people think arbitration as an alternative dispute mechanism is actually a better outcome and a better way forward. And in some circumstances it may very well be. There certainly are advantages to having a matter dealt with by arbitration, least of which is savings on cost. Court proceedings typically cost an awful lot of money. Arbitrations, not so much, but to be fair, arbitrations can be extremely expensive as well. But by and large, your grain contract is going to force you into this type of mechanism. As I said, most contracts I've read do refer to this process. And GTA has promoted this as a process for quite some time, and good luck to it. I am not such a fan of that process for the simple reason that it does lock you into an arbitration process which is not necessarily conducive to ultimately resolving dispute, and there are some, I think, failings within that exercise. One of those is that for an arbitration you need an arbitrator. You are only allowed to pick an arbitrator from the pool approved by GTA. That's a limited number of persons, and it's not necessarily independent. And if you actually have a look at that pool of arbitrators, you'll see a lot of them are actually from grain buyer companies. So I question the independence of that process. Secondly, that arbitration process is underpinned and governed by the Commercial Arbitration Act. It's a statute. It's a common act across each state in Australia, and it effectively locks you out of any primary appeal rights. So if you are ultimately unhappy with the outcome of an arbitration, it's unlikely you're going to be able to appeal that outcome. You're pretty much forced to live with it. And that's a significant difference to a court-based process where you have an appeal right through to the High Court. And so, if we're talking substantive amounts of money, and with grain contracts these days we generally are, do you really want to put yourself in a position where you might have to live with an adverse outcome that you're significantly unhappy about and may not reflect the law? And that's the other part of my concern, is that in an arbitration, arbitrators are not necessarily bound by the rules of law and not necessarily bound by the rules of evidence. And if you get an outcome which seems to be contrary to legal principle, again, you are probably going to suffer a situation where you can't appeal it. And I think that's not necessarily a good thing. Anyway, so they're some of the key issues that I think growers need to be wary of and to look for and consider in grain contracts. Instead of just grabbing that piece of paper that's come through the email to you, signing it and sending it back, have a look at it, have a read of it. If you've got some questions, ask those questions. Ask those questions of the grain buyer. And if you need to seek advice, seek the advice. As with any contractual transaction, it's better to get the issues right at the beginning than to deal with a dispute at the end, because disputes invariably going to cost you time, money and stress. Okay, that's me in the context of grain contracts. What we try to do, what I've tried to do through the course of this broadcast today, is to provide some information and advice on basic common sense issues and some strategies and practical issues for you to actually look at, deal with and work with. As a firm, Bailiwick has experienced personnel. We've got a lot of experience within agribusiness and tourism across all issues dealing with commercial, property, employment, succession laws. And within the team here, we do like to work as a team to assist clients' needs. We value a personal approach and practical application of the law to achieve and drive practical outcomes for each client. So feel free to reach out to me. We do provide consultations, anything up to 30 minutes or so for free to discuss any issues you may have, and hopefully put your mind at rest. So contact me if you wish. Keep safe and well. And whilst I would technically finish right there, I think maybe this is the opportunity. Last session I introed what I'm going to talk about next month. I think though, rather than me saying what I'm going to talk about, perhaps if some people that listen and view this broadcast, if you can give some thought to what you would like to hear more about. And I say that genuinely. I'm quite curious as to whether I'm hitting the nail on the head with respect to the issues I'm addressing, or whether you've got some other sort of pressing issues you'd like me to talk about. One session doesn't need to concentrate on one topic. We can deal with a couple of issues and a couple of series of questions if need be. So please give that some thought. And if you would like me to talk about anything, excluding family law issues and criminal issues. I'm open to that suggestion. So, yep, contact me. Thanks very much.